Chairman, Senate Committee on Judiciary. Of course, the same Senator Mukhail Adetoku. On behalf of members of the Senate Committee on Judiciary, Human Rights and Legal Matters, and indeed the Senate of the Federal Republic of Nigeria, I profoundly welcome you all to this public hearing. Let me also seize this opportunity to welcome as special guest of honor His Excellency Senator Ahmad Ibrahim Lawan, PhD, CON, the President of the Senate, and to acknowledge his dynamic and exemplary leadership in steering the affairs of the Senate. Thank you for accepting our invitation to grace this occasion in spite of your busy schedule to declare this public hearing open. Permit me also to warmly welcome all the principal officers of the Senate here present and the sponsors of the bills, as well as our highly revered stakeholders, members of the public, and ladies and gentlemen of the press. There is no gainsaying the fact that one of the cardinal principles of the legislature is the practice of inclusivity as a veritable platform for collaborating and synergizing with stakeholders in handling legislative proposals and measures geared towards the socio-economic and political development of the country. In realization of this fact, the 9th Senate, in line with its legislative agenda, resolved since the inception of this current dispensation to conduct public hearings on bills and motions before legislative intervention measures are put in place. This is in view of the fact that laws are made for the attainment of the well-being of the people and to meet their yearnings and aspirations. As such, every stakeholder should be carried along in the lawmaking process, whereby all perspectives and viewpoints can be galvanized for the enactment of legislation that can be seen as people-oriented. This, in fact, is the beauty in the art of lawmaking in a democratic government and is one of the ways that our legislations can stand the test of time. Consequently, this public hearing has been put together by the committee in order to avail stakeholders the needed platform to deliberate and brainstorm on the proposed bills with a view to further enriching their provisions, taking into consideration global dynamics and emerging trends for the laws to have all-inclusive and encompassing impact on the people. Accordingly, the committee decided to lump these 7 bills together in one public hearing in view of their strategic importance and the need for the committee to work within the given time frame in order to report back to the Senate. Without further ado, I crave your indulgence to briefly comment on the intendment of the bills under consideration as a prelude to kickstarting today's deliberations. Firstly, the Administration of Criminal Justice Act 2015 Repeal and Reenactment Bill 2022. This bill was sponsored by distinguished Senator Okajev Emmanuel, representing Benue Northwest Senatorial District, and who is also the vice chairman of our committee. The bill, among other things, seeks to repeal the Administration of Criminal Justice Act 2015 and enact the Administration of Criminal Justice Act 2022 to provide, among other things, the institutional and legal framework for the administration of criminal justice system with a view to enhancing efficient management of criminal justice institutions and speedy dispensation of justice in Nigeria, protection of society from crime, and preservation of rights and interests of suspects, defendants, and victims. The bill also seeks to establish the Administration of Criminal Justice Monitoring Council as obtainable in other jurisdictions, similar to the Bureau of Justice in the United States of America and the London Criminal Justice Board. This is with a view to delivering a fair, efficient, and effective criminal justice service in Nigeria, and to improve outcomes through active partnership. Secondly, the Federal High Court Act Cap F134, Laws of the Federation of Nigeria 2004, Amendment Bill 2022. This bill was sponsored by distinguished Senator Mikhail A. Abiru, representing Lagos East Senatorial District, and who is also the chairman of the Senate Committee on Industry. The bill seeks to amend the Federal High Court Act in order to redress some inherent shortcomings in the Principal Act and make provisions for the regulation of the award of pre-judgment interest to ensure the attainment of substantial justice in relation to claims bordering on commercial transactions. For the purpose of clarity, pre-judgment award is precisely an interest which is claimed by plaintiff against a defendant holding monies either as debt or other obligation to the plaintiff for which he is entitled. Thus, this amendment, according to the sponsor of the bill, is apt in view of the fact that the real economic value of interest would have been lost as at the time of judgment, given the high inflationary rates the country is currently confronted with. Thirdly, the Firearms Act number 32, 1959, Cap F28, Laws of the Federation of Nigeria 2004, Repeal and Reenactment Bill 2022. This bill was sponsored by distinguished Senator Sani Muhammad Musa, representing Niger East Senatorial District. The bill essentially seeks to repeal Firearms Control Act number 32 of 1959, Cap F28, Laws of the Federation of Nigeria 2004, and enact the Firearms Control Act 2022 in order to prevent the proliferation of illegally acquired firearms by providing for the removal of those firearms from circulation so as to prevent crime involving the use of firearms. The intendment of this bill is apt in view of the proliferation of illegal firearms, which has posed a great security threat in the country in recent time. Therefore, it is imperative for the legislation responsible for the control of these illicit firearms to be strengthened in line with modern realities to handle the ugly menace. Fourthly, the Violence Against Persons Prohibition Act 2015, Repeal and Enactment Bill 2022. This bill was sponsored by distinguished Senator Jibril Issa, representing Kogi East Senatorial District. The bill, among other things, seeks to repeal the Violence Against Persons Prohibition Act 2015 and enact the Violence Against Persons Act to comprehensively provide for maximum protection and effective remedies for victims of violence in all ramifications. This is with a view to eliminating all forms of violence in both public and private spheres in the country, against the backdrop of the rising cases of violence, hence the need for holistic review of the Extant Act to bring its provisions in line with current realities, such as review of imprisonment terms and fines, introduction of adequate compensation for victims of violence, including the establishment of Victims Support Fund, etc., and to generally conform to normative drafting standards for effective dispensation of justice with respect to the subject matter. Fifthly, the Franchise Regulation Bill 2022. This bill, again, was sponsored by distinguished Senator Mukhtar A. Abiru. The bill seeks to establish the framework for the regulation of franchising and to guide the relationship between franchisors and franchisees, and for matters connected therewith. Certainly, franchise is a well-known business concept, whereby a franchisor sells the right to the franchisee to use the name and idea to carry on business under the existing business model and trade market. Without doubt, the intent of this proposed legislature is apt, as the importance of this viable sector of our economy is not properly regulated through legislation, thereby leading to frustration of franchisees in the country. Accordingly, there is need to have this legislative framework in place to protect and stimulate franchising model in the country. Number 6, the African Union Convention on the Protection and Assistance of Internally Displaced Persons, Domestication and Enforcement Bill 2022. This bill was sponsored by distinguished Senator Frank Ibezim, representing Imo North Senatorial District. The bill, in a nutshell, seeks to domesticate the provisions of the Kampala Convention, signed by the federal government of Nigeria in October 2009 and ratified in April 2022. The domestication being sought by this bill is in line with the provisions of Section 12 of the Constitution of the Federal Republic of Nigeria 1999 as amended, which requires that treaties signed between Nigeria and other countries or international bodies should first be domesticated by an act of the National Assembly. As such, the introduction of this bill at this point in time is not unconnected with the incessant incidences of internally displaced persons across the country, arising from insurgency, banditry, and other communal crises, which have been on the increase in the last couple of years. Therefore, it is expedient that the relevant legislative measures are put in place to ensure that the welfare, rehabilitation, and reintegration of internally displaced persons are frontally handled in line with global best practices. The seventh and final bill for today is the Compulsory Treatment and Care for Victims of Gunshots Act 2017, Amendment Bill 2021, SB 748, which is a joint referral with the Senate Committee on Health, Secondary and Tertiary. This is a joint referral between this committee and the Committee on Health. The bill was sponsored by distinguished Senator Oluremi Tinubu, representing Lagos Central Senatorial District. The bill, among other things, seeks to amend the Compulsory Treatment and Care for Victims of Gunshots Act 2017, Amendment Bill 2021, in order to expand the scope of the extant act by establishing Medical Emergencies Assistance Fund and for related matters. The passage of this bill will no doubt strengthen the extant act, which was enacted to enforce treatment for victims of gunshot injuries, which were refused treatment hitherto, consequent upon the misinterpretation of Section 4 of the Robbery and Firearms Special Provisions Act. In conclusion, ladies and gentlemen, I wish to reiterate the commitment and resolve of the Ninth Senate under the quintessential leadership of His Excellency, Senator Ahmad Ibrahim Lawa, PhD, CON, the President of the Senate, toward the reform of our laws in line with global best practices. And the bills before us today are legislative proposals that are geared toward justice sector reform and the administration of justice in the country for the enhancement of quick dispensation of justice. In this regard, we are ready to carry all stakeholders along in the legislative processes that lead to enactments of these legislations in the National Assembly. It is in line with this reasoning that we are all here today for this important legislative exercise. Accordingly, I implore you all to feel free and make your presentations on the merits of the bill, which will form the bedrock of our recommendation to the Senate. I thank all of you for listening, and at this point, it is now my singular honor and privilege to invite the President of the Senate, His Excellency Senator Ahmad Ibrahim Lawa, PhD, CON, who is here ably represented by the Majority Leader of the Senate, the most distinguished Senator Boroface, to give his keynote address and to declare this public hearing open. Your Excellency, sir.
Chairman, distinguished colleagues, distinguished guests, ladies and gentlemen, I am delighted to be here at this public hearing to consider 7 crucial bills related to the judiciary, human rights, and legal matters, following the resolution of the Senate that the bills should be further examined at the level of this relevant committee. The 7 bills are the Administration of Criminal Justice Act of 2015, the Federal High Court Act, Firearms Act number 32 of 1959, the Violence Against Persons Prohibition Act 2015, and the Franchise Regulation Bill 2022. The rest are the African Union Convention on Protection and Assistance of Internally Displaced Persons, Domestication and Enforcement Bill 2021, and the Compulsory Treatment and Care of Victims of Gunshots Act 2017, which suggests the development of more regulatory mechanisms in important sectors of our national life or the strengthening of the existing legal framework. The implication of this is that the legislature is once more working to improve the legal institutions, which is one foundation for good governance. It is also in line with the role of the legislature as a source of regulatory initiative before consideration and interpretation of other arms of government. Our participation today is an invitation to be part of legal institutions building process as qualified stakeholders through meaningful inputs. This is a core legislative procedure that underscores adequate consultations before final decisions are made on proposals. The Senate Committee on Judiciary, Human Rights, and Legal Matters has prepared well for this event, and my charge to us all is to take advantage of this and make robust contributions. As stakeholders in the evolution of our country, we cannot afford to do less in the interest of future generations. It also falls in line with our innate drive to leave lasting legacies as leaders of conscience. I am confident we are ready to do this given our requisite experiences. While you should be rest assured that the committee will be respectful of your ideas, we are always inclined. I am therefore pleased to welcome you all on behalf of the Senate President and declare this public hearing open. God bless you all. God bless the Federal Republic of Nigeria.
Thank you, Acting Leader of the Senate, for the keynote address. of His Excellency, the President of the Senate.
It's a very important part of our lawmaking process, which is the public hearing. And also to just point out, as you can see, we have almost 7 bills under consideration, which is a characteristic of this committee. It's one of the busiest committees in the Senate, and try as we want to make these public hearings as often as possible. The sheer load of work makes it almost impossible not to have a joint sitting such as this. So our apologies. I know that we have submitted written memoranda, and what we usually ask is for everybody to try to make his oral submission as brief as possible, since you have this. But thank you very much for your time, and I wish you a successful delivery.
Ladies and gentlemen, in commercial terms, particularly the ones for recovery of debts, the claimant should ordinarily be entitled to prejudgment interest on the principal debt sum, should he succeed in his claim. However, entitlement to such a prejudgment interest is not as easy as it seems, and at least as far as the numerous decisions of our appellate courts are concerned. As we are all aware, in Nigeria today, there is no statutory law which regulates the award of prejudgment interest. Nigerian courts, up till date, still have recourse to the English common law practice as a guide in the award of prejudgment interest. And as evidenced by majority of decided cases in Nigeria, in most of those cases where the claims of the claimants on the principal debts were successful, their claims on prejudgment interests were denied. And unfortunately, because the claims did not pass the common law test. So therefore, a legislation and legal framework is desirable to deal with the glaring shortcomings in the law and practice on award of prejudgment interest. And this is the reason why I have come up with this bill. Please endeavor to make your inputs and contributions so that it captures the essence of what we hope to achieve for the good of everyone. I wish everyone a fruitful deliberations. Thank you very much for your attention.
Relevant stakeholders here present. On today's occasion, Mr. Chairman, distinguished ladies and gentlemen, is actually intended to afford critical stakeholders and civil society organizations and representatives of the government MDAs the opportunity to make their inputs and contributions to the work of the Senate Committee on Judiciary, Human and Legal Matters, in scrutinizing the African Union Convention for the Protection and Assistance of Internally Displaced Persons in Africa, Domesticated and Enforcement Bill 2021, as sponsored by my humble self. IDPs are people who have been forced to flee their homes as a result of human or natural disasters and have not crossed an internationally recognized state border. They differ from refugees in that they are not displaced beyond the boundaries of their countries of origin. In Nigeria, for the last 2 decades, the number of IDPs increased astronomically due to the armed conflicts, insurgents in the Northeast, farmers-herders clashes, due to large-scale development projects, generalized violence of political or religious nature, human rights violations, flood and other natural disasters, human-made disasters, etc. The increased number of IDPs on the continent of Africa necessitated the adoption of the African Union Convention for the Protection and Assistance of Internally Displaced Persons in Africa on the 23rd of October 2009 under the auspices of African Union. The AU Convention for the Protection and Assistance of Internally Displaced Persons in Africa, Domestication and Enforcement Bill 2021 is the product of the Kampala Convention, which the Federal Government of Nigeria ratified on the 17th April 2012. The provision of Section 12 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, requires that treaties signed between Nigeria and other countries or international bodies should be first domesticated
by an act of the National Assembly, hence this instant bill. From the foregoing, therefore, the primary motivation behind this bill is to put in place an ideal legal framework and mechanism for addressing core IDP issues in the country. The domestication of the Kampala Convention will pave way for a paradigm shift from relief and humanitarian assistance to IDPs, which appears to be the focus of most IDP interventions in Nigeria, to other germane issues such as prevention, production, rehabilitation, reintegration, and resettlement of survivors, reconstruction of damaged infrastructure, and environmental remediation. It is sad to note that most victims of displacements are left to their fate after the relief phase, or even without basic relief assistance. Mr. President, distinguished colleagues, it is indeed worthy of note that the National Emergency Relief Management Agency, NEMA, the National Commission for Refugees, and the IDP, and other state emergency relief management agencies are first responders to natural or man-made disaster sites in Nigeria. Apart from the IDPs in the states in the northeast geopolitical zone of Nigeria that are benefiting from past relief aspects of IDP courtesy of the Northeast Development Commission, millions of IDPs outside the northeastern part of the country who have been displaced by endless herdsmen, farmers clashes, large-scale project situations, land disputes are still without a holistic interventions in terms of rehabilitation and resettlements, which is the fundamental aim behind seeking for the domestication of the Kampala Convention. Indeed, there is no one here present who is not facing IDP crisis in his constituency as a result of the peculiar challenges we are facing in the country. It is in view of the foregoing explanations that I urge you all to support the speedy passage of this bill. On this note, I would like to once again thank the President of the Senate, Senator Dr. Ahmed Lawan, Chairman and members of the Senate Committee on Judiciary, Human Rights, and Legal Matters, and other critical stakeholders here present. It is my hope that all stakeholders will take advantage of this opportunity to make their inputs so that in the end, the bill will be passed in a manner that will not only be implementable, but also acceptable to stakeholders in the interest of IDPs in Nigeria. Thank you for your kind attention.
Mr. Chairman, my colleagues and invited guests, it is once again is my singular honor and privilege to be invited to this public hearing and to give a synopsis of the Franchise Regulation Bill 2022. The bill seeks to create a framework for the regulation of franchising and to guide the relationship between franchisors and franchisees and for matters connected therewith. And the objectives of the bill are: one, regulate and guide the relationship between franchisors and franchisees by imposing certain obligations and prohibiting certain actions. Also, it is to promote the growth of franchising through the adoption of international best practices that balance the interests of franchisors and the franchisee. As we are all aware, we have mass opportunities. This presents mass opportunities for our unemployed citizens, and it therefore seeks, it creates the time, and I think the time is right for reputable foreign franchisors with solid brands to start expanding their operations in Nigeria, as well as for local established businesses to embark on the franchise journey. This is part of our efforts to enhance economic development of our great nation that has informed the passage of this franchise bill, which basically seeks to create a framework for the regulation of franchising and to guide the relationship between franchisors and franchisees for related matters. Ladies and gentlemen, as important stakeholders who have more specialized information and experience in this sector, I urge you all to avail this committee with the benefit of your expert position, views, and input so that a robust legal framework is put in place to regulate this very important emerging business strategy. I wish you all a fruitful deliberations. Thank you very much.
Ladies and gentlemen, let me just quickly read out the list of the organizations that we have here represented. So if you are here and you intend to make a presentation and your name is not on this list, please just approach the Secretariat to ensure that they write down your name. Ministry of Justice, Ministry of Women Affairs, Nigerian Law Reform Commission, Nigerian Institute of Advanced Legal Studies, the Nigerian Army, the Nigerian Navy, National Refugee Commission, the National Human Rights Commission, Center for Socio-Legal Studies, Secretary, ACJMC, Economic and Financial Crimes Commission, International Federation of Women Lawyers, Joint EU UN Spotlight Initiative, the Council for Legal Education, Nigeria International Promotion Commission, NIPC, Nigeria Investment Promotion Commission, and then finally Nigerian International Franchise Association. Okay.
Name is Major Abba Ali Goni. I'm here to give a little presentation in respect of the aforementioned bills that is displayed before the relevant audience here. Sir, to start with, sir, I want to quickly say that I adopt everything that has been provided in this document as the position of the Nigerian Army in respect of all the bills before this honorable committee. And a copy of it has been submitted to the nominated secretariat for input. So without much ado, sir, the first bill, that is Administration of Criminal Justice Act, I want to draw the attention of this honorable committee that it is not applicable to members of the armed forces. Section 2 of that act clearly states that it's not applicable to us. Sir, secondly, sir, I don't want to take much of the time. The most important one that really affects us is the ones that has to do with firearms. I can see Firearms Act here, number 32, 1959, cap F28, LFN 2004, Repeal and Reenactment Bill 2022. But what we were given was Firearms Control Act, Repeal and Reenactment Bill 2022. That was what was presented to the Nigerian Army to work on. And that was what we did our input on. Firearms Control Act. The Firearms Control Act, that's what we were given to work on, and that was what we worked on. And what I can see here is completely a different bill, Firearms Act, cap F28. So I don't know if I'll be allowed to talk on this particular bill that is not even before this committee. Okay, sir. So the next one is the African Union Convention on the protection and assistance of internally displaced persons, Domestication and Enforcement Bill 2021. My Lord, sir, as the sponsor of the bill rightly pointed out, Section 12 of the 1999 Constitution, Section 12 of the 1999 Constitution as amended clearly made for the domestication of treaties and other conventions that Nigeria is a signatory to. Sir, taking a look at thoroughly what is happening in the Northeast, particularly where we have a lot of IDPs as a result of the crisis there. So the Nigerian Army came up with its position in support of the bill and came up with relevant instances, particularly the instance where the Nigerian Army will form part of the implementation committee of that particular bill for the welfare and well-being of the IDPs.
distinguished stakeholders who are here. My name is Rear Admiral Emmanuel Ogala. I'm here to represent the Chief of Naval Staff, who is unavoidably absent due to other service exigencies. I wish to note that the Nigerian Navy is fully in support of the principles and letters of each and every one of these bills. Particularly, the Nigerian Navy have no objections. I have no observations with respect to 3 of the bills, namely, that's the first 3, Administration of Criminal Justice, Federal High Court Act, and even the Firearms Control Bill. No observations and no objections to those bills. The Nigerian Navy is also in support of the other 4 bills. However, there are a few observations, some of which are typographic in nature, and some of which are just a little contribution to improve the quality of the bill. I'll start with the Violence Against Persons Prohibition Act, repeal and enactment bill. Our observation in this area concerns, I will take them in line with their sections, looking at section 10, subsection 1. Of course, this section provides an offense of forceful ejection of spouse from his or her home. We suggest that the clause, without an order of a competent court, could be added to this section to make it very clear. Section 13, subsection 1. This section creates an offense of forced financial disobedience or economic abuse. The Nigerian Navy observed that economic abuse is defined in the interpretation part in section 54 to mean forced financial dependence. It is opined, or we feel, that an offense cannot define another offense without definition of the particulars of that offense. It is therefore suggested that the offense of forced financial dependence could be deleted for ambiguity. Now, section 14, subsection 1. The Nigerian Navy suggests that the definition preventing a person from leaving home is also is ambiguous and could be deleted. Now I'll go to the second one, which is Franchise Regulation Bill 2022. Generally, the Nigerian Navy is in support of this bill, considering the fact that we also are engaged in lots of things that we benefit from this bill. Since we have commercial arms that go into production, especially shipbuilding and other areas, and R&D. However, the only aspect we want to look at is section 4, subsection 1A, which states that the name and description of the product and business under the franchise. So we also believe that there are some things that are not product or business, so we can also add service. So we can add service after the product. So we have products, services, and business under the franchise.
Specifically making comment on behalf of the sponsor of the bill for an act to amend the compulsory treatment and care for victims of gunshot 2021 to expand the scope, establish a medical emergency as stand fund, and align punishment contained therein with current realities and for related matters. The bill was sponsored, or is being sponsored by Senator Oluremi Tinubu. As Chairman of the Senate Committee on Health, we've had the opportunity of looking at this bill. And what we are trying to do is to align the bill with the 2 other laws. We have the National Health Act that has a provision for treatment of emergencies without recourse to source of fund. But specifically, under that act, there's a provision of 5%, which is to to take care of emergency. The challenge with it was because there's another law when NCDC was established, which gave NCDC to benefit from that 5%. But through a regulation, it's now been harmonized to share the 5% between NCDC for public health emergency and another percentage for national health emergency. So the current Senate has already passed the National Health Emergency Act, which is establishing formally national health emergency in the country. So with that fund existing, what this bill is trying to propose, we want to harmonize it to see that we use those two other laws to cure what this bill is attempting to do. Because the National Health Emergency already is going to draw money from National Health Act 5% of Basic Healthcare Provision Fund, as well as additional fund for National Health Emergency. In fact, in the current 2022 budget, a sum of 1.2 billion was allocated for National Health Emergency. The pilot has started in Abuja with ambulances and so on. So that will be able to take care of this, Mr. Chairman. And that's the position. So our committee and the Committee on Judiciary will work to see that we harmonize and synchronize all the laws so that we get the intent of this bill to be effective. Thank you, Mr. Chairman.
My name is Controller of Corrections, Emmanuel Nwakeze Esquire. I'm Controller in charge of custody at the National Headquarters of Nigerian Correctional Service. My station, I stand in the position of the Controller General of Corrections, Alhaji Halirunna Baba, MNI, FCMC. This bill, particularly, we are interested in the Administrative Criminal Justice Act that has, although all the bills here, we are in support of them, but especially the area we also most interested in is the Administrative Criminal Justice Act Amendment Bill. We have gone through the submissions, and we want to actually commend the people that put the bill together. I think it is a great improvement on the present ACJA, and so many sessions there are very, very relevant. We have made some observations. However, because of constraint of time, we are not able to fine-tune all the observations, but we seek the indulgence of the honorable members of the Senate to give us maybe between now and next week, by Wednesday next week, we'll be able to bring our written submission on the observations we made. But generally, we are in support of the bill. Thank you very much, and God bless everybody.
I'm a Deputy Director, Legal Drafting Department, Federal Ministry of Justice, Abuja. I represent the Honorable Attorney General of the Federation and Minister of Justice. We received the invitation with 7 bills listed, as we can see, but attached to the invitation letter were 5 bills. I think, and I believe, perhaps the other 2, it could be out of a mistake. The bill to make provisions for the regulations of the awards of prejudgment and interest. Before going to the crux of the matter, we should first just observe that the spelling of prejudgment is wrong in the long titles, so that it will not escape the sight of this thing. Then, number 2, the enactment clause started with "be it." The position had long been changed. We've changed that. The current practice is simply enacted, so that too should be taken care of. We have seen the objectives of the bill. The sole intent is to make provision for the regulations of what? Prejudgment and interest. We went through the bill. Initially, it seems to us as if the bill came from the premise that there is no form of regulations of prejudgment interest. We had seen it from that perspective. But we also examined the other way. And when the distinguished senator came in to explain, he gave a good explanation for that, and we quite agree with him. There are regulations, forms of regulations littered in different decided authorities, regulating what? Prejudgment and interest. But it is not captured in the Federal High Court Act, the relevant provision which the bill is seeking to amend. So initially, we looked at it and felt that it exists in Nigeria. Do we need to support this bill when we have it already in existence? Will that not amount to a surplusage or a duplication? But on a further reason, and that would have tempted us possibly to oppose the bill. But on a further consideration, we said, look, it is better if we allow it to come into the bill to form a statutory regulation to work alongside with the case law regulations. So for that reason, we decided to support the bill. Then, we cited the case of Hausa and First Bank that has taken care of that, which recognized the existence of prejudgment and post-judgment interest. This section 2 goes further to decide to elaborate on the procedures of regulations. the circumstances under which prejudgment interest can be granted in Nigeria, that one, there must be an agreement between the plaintiff and the defendant. The plaintiff must first claim prejudgment interest, and he must also prove it to be entitled to it. These are the general positions anyway in law. The court is not the Father Christmas to grant that which you did not claim. So we looked at it and therefore decided to propose an amendment of that second provisions of the bill. Because if you read it as it stands, it means as if the court is compelled, because it reads, the court in the exercise of the jurisdiction shall, meaning it shall be compelled. But we know that the court cannot be compelled under such circumstances, and we should prefer to use the word, the court may grant prejudgment interest, because the word may is consistent with, one, pleading it, proving it, before you become entitled to it. So we support the bill with that modification. We have submitted our memo. You will see it there clearly. Then the second bill is the bill on the Convention for the Protections and Assistance of Internally Displaced Persons in Nigeria. This is another very important bill. We have always indulged in the attitude of going to enter into international conventions and become state parties. But we always feel reluctant and not quickly enough to come and domesticate in line or consistent with Section 2 of our Constitution. So for this purpose, this bill is equally very, very important. But we commend it. We also need to state that although we, from the justice angle, are aware that there is equally a national policy on this area that the federal government has come up with. Number two, we are equally aware that the Federal Ministry of Humanitarian Affairs, together with the agencies under its supervision, are presently working on the domestication of this bill. Following from this, it is the view that there is need for collaborations of efforts between these agencies and this very committee to ensure that no agency is left out in terms of its contribution to make this bill very robust. We've also observed that there are two procedures through which you can domesticate a convention. You may decide to adopt it entirely and schedule it. You may decide to make some modifications as it is proposed here. You can see the executive, the governing board, then you establish the secretariat. All this will require funding. If you look at it, it's just like an agency established in disguise. That is how I see it and how we see it. And the government may be a bit reluctant, perhaps, following the present policy thrust of the government of not wanting to duplicate agencies or cut the cost of governance. We do not want to participate in a situation where we discover that a bill which we so cherish was not assented to. So it is our belief that while this bill is good, this area dealing with this medical emergency and disease should be expunged and modified in a way to make the bill suitable and acceptable to even the government and this other side of the divide.
I am Chile Okoroma MNI, representing the Executive Chairman of the Economic and Financial Crimes Commission. First of all, I want to talk about the provision which seeks to establish the Administration of Criminal Justice Monitoring Council. And our position is that that is quite unnecessary to use a procedural law to set up an agency of that nature which has a juristic personality and has the capacity is empowered to establish offices in different parts of the country with an executive secretary and other people who have tenured appointments in a procedural law. I aware of the opinion that is quite unnecessary, that it should be left the way it is in the extant law, the Administration of Criminal Justice Monitoring Committee. They are already doing a good job. So that provision is, to our mind, unnecessary. And then we have also their other provisions. Principally, we support the bill and our position is that some of the concerns which we have raised be addressed. One of the positive and commendable provisions in the bill is the requirement for a presiding judge to make comments in a case that he is doing. In case he's elevated or he retires, another person can take over from there, because we have had a series of undue delays in the disposal of cases by reason of elevation of judges, retirement, or even death. So if we have that provision, which will enable an incoming judge to take over from where the person who was presiding on it stopped, with side comments to deal with the issue of demeanor, that will help a lot in the speedy disposal of cases and dispensation of justice. So we also looked at another provision that requires the Attorney General of the Federation to call for case files from law enforcement agencies. We felt that that provision needs to be properly balanced. The Attorney General has constitutional powers to initiate, continue, discontinue, or take over any proceedings, and no person can go against that. But taking into consideration the fact that Attorney General is also a Minister of Justice, a political appointee, that provision is liable to abuse. So it may be used for political patronage. So it's very important that that be properly reviewed. So these are what the other comments are in our bill. So we support that Administration of Criminal Justice Amendment Bill, the Violence Against Persons Provision Act, and we also support it. We have made our comments, and we seek that they will be addressed. And then the compulsory treatment of gunshot victims. We also support that bill, and we have made some comments. So on the whole, we just want to thank this committee for this opportunity. Thank you, sir.
Distinguished senators, my name is Henry More. I'm the Director Legal ICPC. I'm representing the chairman of the Independent Corporate and Other Related Offences Commission. I'm only going to comment on the Administration of Criminal Justice Act, Repeal and Reenactment Act, because about the other bills, the numbers 2 to 7, we are in support and we have made no comments. And we have not submitted any position paper, because before the EFC submitted their papers, we had that course to review it together. And I will totally align ourselves with all the comments they've made. Because we went through it together, and when they submitted, I felt there was no need for us to duplicate whatever they have done. So I'm totally in support. And there's another section which he didn't mention on the section. We have asked for the repeal of sections 355 and 359 of the proposed bill. That gives a complainant power to withdraw cases when the cases are already in court. We have had instances where maybe we're prosecuting somebody, then for a criminal offense, the petitioner or whatever is settled, and then they come to court to say we are no longer interested in the case. And by virtue of those sections, most often those cases are struck out. So we have asked for the removal of those two sections. And that's our comment, and we align ourselves completely with the EFCC. Thank you. Thank you very much, sir.
Thank you, distinguished chairman of this committee and other distinguished senators. Now, I'll start with the first one in my paper is on the Federal High Court. Now, it is a welcome development, but what we have seen is that the bill seeks to amend Section 11 of the Federal High Court, and the arguments are there. It's Section 11 that it seeks to amend. And that Section 11, sub 1, says that existing Federal High Court, particularly from the portion that reads, all such remedies. So if we say all such remedies, and then which can be interpreted in the court and argued by judges and lawyers and all that, in that regard. But it is just an explanation, further explanation of that Section 11.1. Well, there's some editing there, very simple. Instead of the word prejudgment, you say prejudgment, and so on and so forth. Now, the next one, on violence. The bill is also a welcome development. The bill seeks to repeal the Violence Act, Persons Act. Now, there is this argument that clause 29, 1 and 2, the use of high court should be clearly defined as in clause 28 for consistency and clarity, since high court is not defined in the act as the word court. So if you look at the word definition of court, and then you say high court, and then you say federal high court, you see, we have to be very consistent in the act, in the law, so that it can convey exactly which court you have in mind. Then the other one, the rest of the comments are there. Then the other one, which is on victims of gunshots. The victim of gunshots, what the representative of the Attorney General said concerning the fund, well, the Commission is of the view that there need to be clarity on how the fund will be implemented in practical terms. It is very silent. It just like, he said something, I don't want to repeat what he said. So the bill is silent on how the fund will be accessed or disbursed to who the bill is meant for. It does not clearly state how and so on. So access to the fund for the emergencies need to be, the explanation is there on that, yes. How do you access it? When and how? In what way? Okay, in what ways? Then the other one, the other one is on franchise. It is a welcome development. It's a replica of Malaysian law. It is believed that if the law is passed in Nigeria, it will bring about positive results in the economy as it is going to be, as it is done in other climes. But there are some editing issues there. The bill did not provide for a short title or citation section. The long title should be rephrased to state that a bill for an act to regulate, for example. Then clause 21 should be renumbered correctly by inserting subclause 1 in the first paragraph, since it has a subparagraph 2. So these are just minor things.
Fellow stakeholders, we have made copious comments on all the bills, and we've already submitted that. But particularly the bill on the administration of criminal justice, we have quite some concerns. In respect of section 34(4), we think there should be a time frame when a request to the Office of the Attorney General should be made, and he responds. We think 48 hours should be okay. Under section 103B, we think there is a need for a time limit also within which to transfer a case where the cause of complaint arose out of jurisdiction. Under section 113(7), we think that which deals with a request by an HRC of returns from the Chief Judge, we think there should also be a time frame. If we make that request, we think 48 hours should be also okay. We think under section 234, where the judge can try some cases in secrecy, we don't think cases of economic and financial crimes should be included among the cases that can be tried in secrecy. It is okay if we try justified cases of terrorism and trafficking in persons, but we don't think economic and financial crimes should be there. And in respect of section 406, which prescribes punishment of death by hanging or lethal injection, of course, we in human rights don't think that the death penalty should be sustained.
we think that life imprisonment should be okay in that case. Anyway, in Nigeria, there are hardly execution of death sentences, and after the report of the National Study Group on death penalty, officially Nigeria has placed a moratorium on execution of death sentences. So I think our laws should start being in sync with that position of Nigeria, so that we don't continue to increase number of incidents where we have capital punishment. We think life imprisonment is okay for that.
And the control of the firearms is very necessary, and we are very grateful that this is being done, so that, because we all know the security of the country today, and we are all aware of what is going on. So we need to control this, and we are aware that we have a committee that is on small arms control with the National Security Advisor. We are a member of that group. Secondly, the Franchise Regulation Act, as suggested, we are very happy with this, because we have a lot of our facilities that have been franchised out, that we have a lot of partners that are working with us. We want a way where we can have regulations that we bind us and we bind them, so that at the end of the day, we can do a very good job for the benefit of the country. And again, in all others, administration of criminal justice, most of them, we are all aware of what is going on. The African Convention for the Protection and Assistance of Internally Displaced Persons, we have officers in all the local governments, and we have to deal with a lot of both Nigerians and non-Nigerians. Either you are legally in the country or you are irregular. And as a result of that, a lot of them, especially from across the very close countries we have, like Niger, Cameroon, and co, do filter into this country, and at times they enter into this. This is very good, and we hope that the good job you are doing will continue. Thank you, sir.
My name is Casey Ume. I'm the Assistant Legal Advisor of Federal Ministry of Women Affairs. And we worked on the Violence Against Persons Prohibition Act, repeal and enactment. Most of the things we noted have already been highlighted by the previous speakers. However, I will have to stress on just these 2 points. We have like 12 things we've outlined. One is on the long title. We feel it's good to have the long title include the establishment of Victims of Violence Support Fund, in line with the fact that long title is intended to provide a summarized description of the purpose of any instrument. Finally, I will talk on Section 54 on Protection Act, Protection Order, which dealt on protecting people who are being threatened. We know that at times people can be sinister enough not just to target somebody, but they can target your loved ones, your child, your spouse, or however. So if this is captured, we will appreciate that. We support the bill in total, and my ministry, especially my minister, is really, really happy about the issue of Victim Support Fund being captured in that bill. It's a very welcome development and laudable. Thank you.
My name is Prudence Okwaravero, and I'm representing the Nigerian Institute of Advanced Legal Studies. In response, we have submitted both soft and hard copies of our comments, and we are adopting it in total. However, there are a few clauses on the various legislations I would like to highlight for emphasis. On the Administration of Criminal Justice Act 2015 repeal and reenactment, Section 332 sub 2, it is our recommendation that it be expunged, as the ACJA is a federal legislation and there should be no mention of the Consolidation Revenue Fund to avoid conflicts. Also, Section 393 sub 3 may not be practicable in all cases, given the busy nature of the courts dockets. Also, we recommend consistency because we realize that in some parts, some clauses of the bill, reference was being made to correctional center, and in some other clauses, reference was made to prison. So there should be consistency when referring to the custodial center.
My name is Ogechi Abu, and I'm a past publicity secretary of FIDA Nigeria. Our memo is limited to 3 of the bills, being the Violence Against Persons Prohibition Act 2015 Repeal and Enactment Bill, the African Union Convention on the Protection and Assistance of Internally Displaced Persons Domestication and Enforcement Bill, and of course the ACJA Amendment Bill. So on the VAP bill, the VAP Amendment Bill, we observe that the bill does not contain a table of content, and we are recommending that it's necessary for the ease of reference for users of the law that this table of content be included. Then on section 2, we made some observations on the penalty. We are suggesting, and in fact recommending, that a uniform sentence be prescribed for offenders, irrespective of the age of the child, because we find this disparity in sentencing vis-a-vis as it relates to the age of the child. And in fact, we have quite a worrisome situation where it would appear that a lesser sentencing is now prescribed for defilement of children between the ages of 16 and 18, as opposed to defilement of an adult. So this bill is now prescribing a maximum of 10 years for defiling a child between 16 and 18 years, but prescribes 12 years, a minimum of 12 years, and maximum of life imprisonment for defiling an adult. And then we don't think that this is an appropriate situation. In fact, we are recommending strongly that this particular provision should reflect the spirit of Section 31 of the Child Rights Act, which prescribes life imprisonment for this kind of offense against a child.
Thus, the NCFRMI is proposing some amendment to some section in the bill that will likely lead to duplication of roles for different agencies. On this note, with utmost respect, I take the liberty to recognize and applaud the commitment and consistent effort of the government and our dear President, His Excellency President Muhammad Buhari, in ensuring a coordinated approach towards social inclusion to combat the effects of poverty and for strengthening the nation's existing social safety net initiatives and providing succor for IDPs and all other persons of concern. At this point, I want to extend my appreciation to the Senate Committee on Judiciary, Human Rights and Legal Matters for their effort in the process of domesticating the African Union Convention. It is anticipated that the passing of this law as a stand-alone bill will further the achievement of humanitarian assistance and protection to our persons of concern. I want to emphasize that the Commission is in the support of collaborative effort of relevant stakeholders to adequately capture an interagency and multi-sector approach to displacement response and management.
My name is Camila Farouk, the legal officer from Women's Rights Advancement and Protection Alternative. My presentation is on behalf of the Joint EU-UN Spotlight Initiative. Due to the time restrictions, I'll keep this very short. Most of our issues and recommendations, we align our views with most of the points raised by FIDA. We have about 5 issues, but first of all, we will start by commending the creation of a VAP coordinator in the FCT and also the expansion of the scope of service providers. The second, one of the recommendations that we have, which FIDA also mentioned, is the absence of table of contents in the bill, which is necessary for ease of reference for users of the law. The second issue and recommendation that we have is Section 2. We suggest that a uniform sentencing should be awarded for offenders irrespective of the age of the child. The punishment for the defilement of child reflects the spirit of the Child Rights Act, which is life imprisonment. So how can the punishment for defilement of a child between the ages of 16 and 18 as proposed by Section 2, subsection 4, which is 10 years maximum, be less than that of an adult as provided in Section 1, subsection 2, which is 12 years minimum and for the maximum life imprisonment? Another recommendation is the jurisdiction of the court. The provision of this bill states that only the High Court of the Federal Capital Territory empowered by the Act of Parliament shall have the jurisdiction to hear and grant an application brought under this Act. We recommend that other courts be allowed to have jurisdiction, including magistrate courts, special mobile courts to cater for the needs of gender-based violence cases, women, children, and persons with disabilities. The High Court, which doubles as family courts, are overwhelmed with cases, making these special cases suffer long adjournments and the victims die out without getting any form of justice. Also, want to touch on Section 12. Under the forceful eviction from home, we recommend that attempting and abetting should be categorized as one provision with proportional penalty instead of separate provisions. Also, on Section 13, we recommend that personal should be added to the caption. Therefore, it should be read as depriving a person of his or her personal liberty. And then finally, for Section 20, we recommend that the offense should include cyberbullying, looking at the current realities that we are in.
Particularly, we are particularly interested in the franchise bill. The franchising, as the Honorable Senator, distinguished Senator Abiru said, been a catalyst for the growth of economies in many nations, but has been impeded in Nigeria because of a lot of unfair practices, and that's why we're delighted about this bill that hopefully will checkmate these practices. However, there are two areas that we would like to also just highlight in terms of further input. The first one was articulated by Professor Akinsheye George, Senior Advocate of Nigeria, about the word regulation. And I think it was well articulated that maybe it should just be franchise bill rather than franchise regulation bill, because the agency is supposed to make regulations or further regulations apart from the act itself. And the second one is to propose, as we have now in KAMA, is the first time, the new KAMA, where BRIPAN, a private organization that's recognized, Nigerian organization, but a member of an international organization, is meant to regulate the practice of receivership. So the same thing with those who are involved in franchising, that we could have an association that works with the government in doing public-private sector promotion of franchising in Nigeria.
We just want to hammer on one point, and that is Section 408, sub 1 of the Act, which prescribe where a woman is charged and tried for a capital offense who is pregnant, that pronouncement of death can be made on her. We feel that we are not against the punishment, but we are of the view that if death sentence is pronounced on a woman that is pregnant, it's like sentencing two persons to death, the unborn baby. So we have the view that the woman should be allowed to deliver her baby before the pronouncement of death is made on her. Then there are other very important amendments too that we have recommended. Thank you, Mr. Chairman.